Hey guys, it's Shawn. We're talking about contracts. We're specifically talking about boilerplate in contracts. Boilerplate may have been something you've heard about in the past. Maybe you don't fully understand what it is. Maybe you don't understand the risks associated with it. But we're going to fix all of that today as we jump into today's video about being aware of boilerplate. So let's just jump into it. Again, we will not be doing legal advice here. We'll be educating you and entertaining you. Consult your legal advisor. Also, no financial or investment advice. What is boilerplate? You might be wondering, you might have seen that term floating around. Boilerplate is this kind of language that is supposed to be standard among agreements. It's supposed to just be copy and paste it in there, right? So the idea is that you have kind of these standard provisions, standard terms that go into every contract. But a good contract drafter will tell you that you often want to adjust the boilerplate or adjust these standard provisions for the particular terms of the contract. And they can be adjusted in such a way that can be beneficial for one party or another. Today, I have a treat for you. We're going to be looking at the Twitter acquisition contract between Elon Musk and Twitter, which at the time of filming is still a hot item as the litigation goes on, right? So their use of boilerplate will show us kind of what they did. We'll look for some insights and some ideas we can learn from them, but we'll also look at the language they included and how you might want to tweak it for your upcoming contracts or agreements as you're working with your lawyer to get those things tuned in for your particular situation. So that boilerplate is those standard provisions at the back of the agreement, generally at the back of the agreement, and they really govern how things work together. Why does it matter? Because these things often hit on important topics. While it's often dismissed as boilerplate, it can impact things like interpretation, amendment, assignment of the contract, who can transfer the rights to the contract. It can hit on issues like litigation, how litigation happens, where litigation happens, right? So these things might seem unimportant at the time the contract is negotiated or written, but by the time something goes wrong, that boilerplate may become very important in determining how the contract is worked through. So let's take a live example here from Elon Musk and Twitter. And we're looking here at the Form 8K filed by Twitter. This was filed when Twitter announced about the merger and they wanted to get the merger agreement filed. As a public company, Twitter is under an obligation to file current reports on things that happen to them. And so here we see their 8K current report. This was filed with respect to what's happening with their stock. So let's just jump into it. And they talk about how they entered into a merger agreement with Elon Musk's entity, X1 Holdings. This is very common here. You can see I'm reading under item 1.01. It's very common when you do a contract like this, when you do a merger, to have some merger entity on the other side that is just named some random name to do it. So they set this up with an X1 Holdings as a parent, X1 Holdings 2 as the subsidiary, and Elon Musk joined directly for some provisions, right? So this is important because X1 Holdings, X2 Holdings probably don't have very significant assets. So that's the basics of it. We're going to keep moving here. We don't want to tear this whole agreement apart. We could spend an entire video doing that. And if that is something you would enjoy, join me in the comments. I always like when you guys comment. It helps. So let's jump to this agreement and plan of merger. You can see here, looking at the table of contents, this is laid out the way most agreements would be, talking about what the deal is, talking about what happens, got reps and warranties. Yeah, usually these jump in around Article 4 or 5. Representative warranties going both directions, covenants and agreements. These are things that people are agreeing to as this thing goes forward. Conditions to the merger, termination, and then here we get where it says general provisions. Some contracts will call this miscellaneous. So our interest will be in Article 9 today because this specific video we're talking about boilerplate. And again, if there's things you want covered in other videos, just go ahead and comment below. I'll pick up those comments and I may do some videos on some viewer interest. And never comment with anything confidential on Twitter, obviously, because your information is important, and if it's confidential and proprietary, I want you to keep that to yourself. All right, so now we're getting down to Article 9 as you watch me scroll on the screen here. Let's talk about some of these, quote, boilerplate provisions, why they're important. And this may also give you some ideas for revising them in terms of the contracts that you will be entering into. All right, so the first one is non-survival of representations and warranties. Survivals of reps and warranties. These are where people are saying certain things are true, and then the warranties are where they're actually saying, I'll guarantee this is true, right? These are important for factual bases, right? You want to know about the other company. You want to know about their financial condition. You want to know about their authority to do the transaction. These types of things you'll typically see earlier in a contract. Now, a big question is, when do they terminate? When do they end? And you may think it's boilerplate, but it can be moved around a little bit. And sometimes you want those representations or warranties to, quote, survive, to keep going. So if you find a problem later, maybe after you acquired the company in the case of this merger, you want somebody to go after, right? But they really put a limit here on this with their non-survival provision. So you might see these things as copy and paste, but good lawyers will be examining these and potentially adjusting them. Notices. Where do notices go, and how are notices delivered? Now, this seems like completely boring, sleep it off, what happens here, right? But this can become very important. I recently had one of my clients. We were trying to notify somebody of some upcoming corporate transactions, right? The notice provision, how and where we notify them, became very important. So this becomes important because you want to comply. Obviously, if you're going to notify somebody, you're going to sue them. If you're going to notify them of some change, how can you notify them, and where do you notify them? This provision is telling us that, so that we know how and where to carry this out. Interpretation. Now, there's a provision, 9.3a, I found very interesting. So you can see they said, and this is common for large commercial transactions, the parties have participated jointly in the negotiation and drafting of this agreement, right? So what they're saying here is, don't hold one side or the other responsible if there's a problem, right? Well, that's the next clause says. Basically, if this thing's unclear or there is some argument about, who gets the rights, one of the contract interpretation tenets that a court sometimes uses is you can screw the contract against the drafter. You use the better interpretation for the person who didn't draft the contract. Well, they're saying, hey, neither one of us are going to be handled as the non-drafter. And even with a contract as sophisticated as this, with the passage of time, the changing of wording, changing of facts, as time progresses, there could be an interpretation issue in the future, right? There's talk about what happens about whether you disclose a fact and whether that's an admission, right? Again, minor here, doesn't seem important because it's quote-unquote boilerplate, but this could become very important to litigation. Severability. This is another standard type provision we see here. What happens if part of the agreement is bad, right? And this is what most people opt for. If an agreement provision is invalidated by a court, the rest of the agreement stands. So that is important to put in there, because if you don't put it in there, you may hit a situation where a court invalidates an entire agreement. Assignment. Who can you assign this to? Sometimes, and this happens a lot in the residential real estate area, one person will sign the contract, but you want somebody else to actually perform the contract. Maybe you identify a property, you sign a purchase contract, but you really want your LLC or some other entity to do the acquisition. This assignment provision, again, while they seem standard, really becomes important. Can you assign this contract to somebody else, or does it have to be the same people over and over again? Entire agreement. This is also called a merger clause because you're merging all the agreements into one. It says it's the entire agreement and it supersedes all prior understandings of the parties. So whatever Elon Musk, Twitter, these merger entities all agreed to prior to this have all now been merged. So you want to review this. This could be important. Maybe you have a separate non disclosure agreement. You want to keep that non disclosure agreement alive. This merger clause could theoretically foreclose that opportunity, right? So you want to be very careful about this. No third party beneficiaries. This is saying other people can't sue about this. Now, sometimes you do want a third party beneficiary. Maybe sometimes you want a bank or somebody who is somehow tied into the deal to actually be able to benefit from this contract. So you may want to change this provision. Governing law. Where is this thing going to be governed by? Whose laws are going to control it? Very, very important for international deals, right? Because the legal systems and legal standards can be really different. But even within the U.S., we may get different outcomes based on the laws of different states. So we want to think about this. You may want to replace the state in here with a different governing law. And then you can see there's a specific performance section here. And there's talk here about how the parties can actually force the other party to do the contract, which now has become a very important provision, right? It's buried in this quote-unquote boilerplate section, general provisions, end of the contract. But those that have followed factually what's happening with Elon Musk and Twitter, there is currently a push to do specific performance right now. So these provisions have become absolutely critical. 9.10, consent to jurisdiction. This is where you're going to litigate at, right? Are you litigating? Are you arbitrating? Which court are you using? Where is that court, right? These are important provisions that become critical later. So you may just think, oh, let's just copy whatever somebody else has. Well, is it the right court system for you to be in? Are you happy with that court? Do you think it'll work out best for you? Do you want to negotiate that, right? So that's an important provision. Counterparts, pretty standard here. You could sign this agreement separately, right? This is almost standard now in the modern age that everybody signs the agreement separately and then everything gets attached electronically. Waiver of a jury trial. Again, important because one of these parties might at some point think it'd be better to have a jury trial, but you can see here there is a waiver provision saying you won't have a jury trial. Assuming that's an enforceable provision done correctly, you won't have it, right? So all of these provisions become very, very important to the overall agreement, but each one standalone doesn't look like it's that important. So this is why we need to look at this boilerplate, and I hope that gets you a better understanding. Let's pull all this together for us. What can we learn? We learn that these provisions look like they're boring, but they are critically important, and we learn from that. So what we want to do is we want to examine that boilerplate, and we want to understand how it impacts us. How does it work in our situation? Is it the best possible outcome? So don't just copy and paste a boilerplate. Just don't bring it over from another agreement. You actually want to read these provisions, understand them, examine them, and think about your particular deal and outcome. So, folks, thanks for joining me today. Hope you subscribe to the channel, ring the bell for notifications, give this video a like, and I would really love to hear from you in the comments. I'll see you down there.